It is almost time to wake up Green Day, which means we are getting very close to the opening of Supreme Court's fall term. So how caught up are you on what's going on in the federal courts? Well, let's get you over the finish line, shall we? Happy Wednesday, everybody. I'm Brian, and this is the morning report on the federal courts for September 24th, 2025. Please double tap your screen, comment, and let me know whether that Green Day joke was too generational. And check out the link in my profile for my wish list and other ways to help me keep this going as we gear up for SCOTUS season. Hold on to your mugs, everybody. Law is not a spectator sport. All right, let's get to the news. Now, we are going to start with a California state case, Noland v. Land of the Free, and I am just going to read to you directly from the Court of Appeals here, okay? Direct quote. Here we go. This appeal is, in most respects, unremarkable. What sets this appeal apart, and the reason we have elected to publish this opinion, is that nearly all of the legal quotations in plaintiff's opening brief and many of the quotations in plaintiff's reply brief are fabricated. That is, the quotes plaintiff attributes to published cases do not appear in those cases or anywhere else. Further, many of the cases plaintiff cites do not discuss the topics for which they are cited, and many of the cases do not exist at all. These fabricated legal authorities were created by generative AI tools that the plaintiff's counsel used to draft his appellate briefs. Ooh, that one hurts. Okay, so as a result of this, the appeal in this case was held to be frivolous. The attorney's client lost her case, and the attorney was fined $10,000 for filing a frivolous lawsuit, which the court points out was actually very conservative because the attorney seemed genuinely sorry. So, there have been a few stories lately about an attorney filing a ChatGPT lawsuit, and every time it happens, I remind you guys, ChatGPT is not a lawyer. Which is also why when you guys get an answer to a legal question from ChatGPT or Claude or whomever, I politely suggest that maybe we want to do some more research. So, learn from this guy, everybody. Law and AI do not mix. Be careful. There is no shortcut to actually reading. Okay? All right. Now, unfortunately, the next story is a bit more serious. Earlier this month, the U.S. Department of Justice told a federal court that because 11 migrants could not be deported to their home countries due to fear of torture, they would instead be deported to Ghana, who had assured the federal government that they would not send the migrants anywhere that they were likely to be tortured. However, the feds stated that they had no authority to control how Ghana treated the migrants after the deportation and accepted Ghana's pledge not to send them onward. And we've heard this from the administration several times. They're sending people somewhere. They've promised to take care of the people there, but basically we absolve ourselves of responsibility as soon as we hand the people over. And essentially, probably predictably, as soon as the migrants arrived in Ghana, Ghanaian authorities transferred all 11 of them back to their home countries, which they had fled in the first place for fear of torture. Now, the plaintiffs, the migrants who also claim to have been shackled, put in straitjackets for 16 hours at a time, and denied legal counsel, all while in U.S. custody, tried to get a U.S. district court to intervene and stop their removal from Ghana to the countries that they had originally fled. But last week, the district court in D.C. said that because it lacks jurisdiction in Ghana, there's nothing it can do and must deny the plaintiff's motion for a temporary restraining order, though the judge did not sound very happy about it. The migrants, part of a group of 14 deported from the U.S., had sought protection under international asylum standards and filed suit in Ghana to block their removal. Their lawyer said the government deported them before they could meet with counsel, calling the rush transfers precisely the injury we were trying to prevent. Some have since gone into hiding to avoid torture. Now, I hate to toss in these sad stories, but we need to pay attention when these occur and keep track of all of these cases. Okay. Let's back out a little bit and end on something a little higher, a little lighter. Okay, we're going to check in on Ball v. East Franklin Superette and Kitchen. So a group of people in North Carolina filed suit after photos of them protesting drag shows and holding up signs saying things like "Stop Grooming Children" were manipulated by a North Carolina restaurant to show them holding promotional messages for the restaurant, including an ad for a drag brunch. The protesters sued under the Lanham Act, arguing that use of the manipulated images violated trademark law, which gives me a little chance to tell you guys about trademark law, which is one of my favorite subjects. So, if I sell rubber duckies, and I make one heck of a good rubber ducky, and I put lots of time and energy into making sure that my rubber duckies are very well made. I mean, Listen to that squeak. Okay, what's the point of doing all of that work if nobody knows which ones are my rubber duckies? If they're all the same, why buy Brino's duckies? Okay, so I am going to put a little B on mine. Boop. There we go. Okay? So everybody knows that these are the ones I made. I put a ton of work into them, and that if you play with one and like it and you want more, find the duckies with the B on them. They're a little more expensive, but I think they're worth it. What I've just done is marked my ducks for trade, commerce. So when people go to the store, they know to buy Brino's ducks, the ones with the B on them. We call that a trademark. It's not about the mark, it's about the quality of the product. But that's why we protect trademark, because if some guy is making crappy ducks and putting a B on them so he can sell them for more, you're not going to know which ones are my good ones, and I'm going to lose money because people will start thinking Brino ducks aren't that good, and he's going to be able to charge more for his crappy ducks. Nah, because people can't tell the difference. So I'll have, and this is important, a commercial financial loss. So I'm allowed to say, no, buddy, you are not allowed to put a B on yours. That's my trademark. Okay, that's trademark law in a nutshell. Well, these protesters sued under the trademark law called the Lanham Act because the pictures of them were used on an ad for the place that they were protesting. But there's no commercial financial loss here. They were just embarrassed because they were being assholes. And since the protesters did not suffer a commercial financial loss from the photos, the Lanham Act is not applicable. Trademark law does not protect your feelings. And so the federal duck dismissed the case. And these guys can go duck themselves. All right, that is your Wednesday morning report on the past day in federal courts. Don't forget to wake up Green Day. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot, and have a great day.